Good morning, all of you. We were discussing about the employee compensation under Employee Compensation Act of 1923 or the Code on Social Security 2020. We were discussing about the dependents. We discussed the first category. I mean, there are three categories of dependents: first category, second category, and third category of dependents. We discussed the first category of the dependents. Who all falls under first category of dependents?
So widow,
Wait, wait.
let
Widow. So widow included in a first category of dependents. Uh, I said whoever falls in a first category of dependent, they need not prove that. So they were dependent upon earning of the deceased. So they got an absolute right to claim for a compensation, whether they are or they were dependent upon the earning of the deceased or not. So widow. So widow can claim for a compensation under since she falls in a first category. And we also discussed the subsequent event, say like the remarriage is not at all a bar to claim for a compensation. So even if she like remarries again, I mean she'll be having a right to claim for a compensation, because the question here, this is the question of fact, not the question of law. It is the question of fact, in the sense during the time of the death of the husband, whether she was dependent or not. So suppose in case, dependent in the sense, she need not depend upon the earning of the deceased or not, because it is understood that during the time of the death of the husband, she was dependent. That's what she got an absolute right to claim for the compensation, being a widow. And uh, next person.
Sir, a minor legitimate son or an adopted son.
Exactly, the minor legitimate son. I repeat, the minor legitimate son. Legitimate son. But he should be a minor. He should be a minor. Minor legitimate son or minor adopted son. Who is a minor legitimate son? Who not at attained the age of 18. So now minor legitimate son, so he can, during the time of death of his father, so he can claim for a compensation. Compensation, being a minor legitimate son or minor adopted son. Adopted son. Now, sometime, the question comes whether posthumous child. Have you heard about a posthumous child? Posthumous child. Posthumous. Who is posthumous child? I'll write a posthumous son. Posthumous son. Posthumous son means a son born after the death of his father. Death of his father. Child born or son born after his father. Question whether legitimate son also includes the posthumous son? Posthumous son? The answer is yes. The posthumous son, the son born after the death of his father, also must be treated exact like the legitimate son, and he is dependent. He falls in the first category. I repeat, the posthumous son also must be treated exact like the legitimate son. A son born after the death of his father. Clear? Now, question comes whether child in mother's womb has any right to claim for a compensation? Child in mother's womb. Look at the law goes to this extent. These are all question comes. The child in mother's womb. Whether child, can we say that child in a mother's womb is a dependent? Can we say that after having this many discussions, uh, can you endorse the child in a mother's womb is a dependent? Can we treat exact like a legitimate son?
Yes, sir.
Absolutely.
Yes, sir.
The child in mother's womb also must be treated exactly like a legitimate son. The question comes, when child in a mother's womb can claim for a compensation? When he or she can claim for a compensation. And we said he or she is a dependent, and we know that in a Employee Compensation Act, the suit must be filed to recover the compensation within 2 years of the incident. 2 years of the incident. 2 years in the sense this is a limitation period. 2 years limitation period. This 2 year starts from the date of injury or any course of action rise or any incident happens. When injury happens from that day, so 2 years. This is what for the recovery they can file a suit within 2 years. That is the limitation time. And during the time of the death, the 2 years from the date of death, 2 years from the date of death, suit must be filed to recover the money or the claim. See, very interestingly, in one of the case, the project officer Giddy A. Kolairi versus the Sanjay Prasad Chaurasia and another. I repeat, the project recently it happened in 2005. Project officer Giddy A. Kolairi versus Sanjay Prasad Chaurasia and another. Sanjay Prasad. In this case, a son of an employee claimed for a compensation after the 29 years after the death of his father. Imagine. In this case, Project Officer Giddy A. Kolairi versus Sanjay Prasad, the case, a son filed a suit to claim for a compensation after 29 years. 29 years after his death. Now, the question comes whether court should entertain this case or not. In this case, during the time of death of his father, he was in womb. This is what we are discussing, the child in a mother's womb. Now, defense naturally employer always try to escape from the liability of paying the compensation. Similarly, in this case, employer took some defense. What defense employer had taken? Employer have taken a defense that the son who filed a case is not at all a dependent. This is what the one claim. What the is not dependent. not dependent. This is what the claim, what defense, what the employer was taken. And another defense they were taken, and it is barred by limitation. Barred by limitation. Limitation. Now, High Court, they answered the question, the first question, whether he was dependent or not. Whether he was dependent or not, or whether he is dependent or not. The court said he is dependent. The court rejected the defense or contention made by the employer. And the court said we cannot deny the right of a person, and since he is a dependent, he is dependent. The court said he is dependent. Dependent. Now, one more question, I mean, defense what the employer was taken, that is, it is because the suit was filed after 29 years. And even court opined that yes, this particular claim must be rejected because it is barred by limitations. Because in case if he want to file a suit, he could file a suit once he attains the age of majority. And why there is a delay? Why there is a delay? He filed a suit after 29 years. Just imagine. So court said even if the 2-year limitation time, sometime, so this is a case, so court also must be taken into consideration the majority age. So he could file a suit on at the 18th year when he attains the age of majority. So court rejected the contentions made by the employer, in this case the project officer Giddy Ekolari versus the Sanjay Prasad Chaurasia. That's what even in this case what I wanted to communicate. The minor legitimate son or legitimate son also includes the posthumous son, one hand, in the sense a son born after the death of his father. And one more thing, the child in mother's womb is also having some right. So hope you understood. So these the explanation. Any questions? And next category, I mean, first category, who else? Minor, legitimate son or adopted son. Who else?
So unmarried daughter or unmarried legitimate daughter or a widowed mother.
Unmarried, legitimate daughter,
or adopted daughter.
Adopted daughter. So daughter, when it comes to the daughter, what is the dependency age? There is no age bar. In a son, we could see the minor. But when it comes to the daughter, legitimate daughter, there is no age bar. So marriage is a bar until she get married. So that is the age. So until her marriage, so she is dependent. And we also discussed about unmarried daughter also includes the widowed daughter. This is we discussed yesterday, who is being maintained by her father during his lifetime. Because a daughter undoubtedly acquires a new relationship on marriage, but she doesn't lose the old relationship. She remains a daughter. Once a daughter, always a daughter qua relationship. She is daughter before, during, after marriage. Clear? Therefore, a adopted unmarried daughter would be included in a unmarried daughter, one thing. And I also said the unmarried daughter includes widowed daughter. But unmarried daughter does not include a daughter who has been divorced. So this is what we discussed. And At last, we discussed one more person who falls in a first category. Who's that?
A widow mother.
The widowed mother.
Mother.
Widowed mother. Mother falls in a third category, but widowed mother. Widowed mother. Widowed mother. Whether widowed stepmother is included, whether widowed stepmother is included,
No.
only widowed mother. Only widowed mother included. Widowed stepmother is not included. Even stepmother is not included. Mother is included in a third category, but widowed mother included in a first category. Whether she need to prove that widowed mother, whether she need to prove that she was dependent, or she got an absolute right.
Absolute right.
She got a absolute right. Why she has absolute right? Because she falls in a first category. First category. She falls in a first category. So this is what the category first. So let us discuss the category second. But we also discussed for the purpose of ESI, the adopted son, the dependency age continues till 25 years. 25 years. That in detail we will discuss when you are discussing the ESI. So this is what we discussed in yesterday's class. So we'll discuss now the second category of dependent. Anybody want to read?
If fully dependent on the earnings of the employee at the time of his death, a legitimate or adopted son or a daughter who has attained the age of 18 years and who is infirm except for the purposes
Who
of
is
chapter 4,
infirm? Who is infirm? Stress that word. Who is infirm?
who is
Okay.
infirm except for the purposes of chapter 4, wherein the word 18 occurs in subclause, shall be deemed to have substituted by the word 25.
Okay. I said in a chapter fourth of the code on social security deals with the ESI. For the purpose of ESI, the age in this particular subclause, so you must read not as 18 but as a 25. 25. 25. Now, if wholly dependent on the earning of the employee, see, so far we discussed in a first category, we have not discussed whether they are dependent or whether they were dependent. Now, when it comes to the second category, very clearly it says that they must wholly dependent on the earning of the employee or earning of the deceased. So, a person who wholly is on earning of the deceased or earning of the employee, who a legitimate or adopted son or a legitimate daughter who has attained the age of 18 years. Very, very important. They, in case if they have not attained the age of 18, they falls in this category, A category. But here, they must attain the age of 18. But they must be infirm. They are physically incapable. Infirm in the sense they physically they are or mentally they are incapable. Incapable. So who falls in a second category? Those who attains the age of 18, I mean legitimate son, adopted son or daughter who already attains the age of 18, but they are infirm. They are infirm. Physically they are incapable. Mentally they are incapable. So what they need to prove? They need to prove that yes, they attain the age of 18 and they are infirm and they need to they need to prove that they were dependent. Whether partly dependent, answer is no. They must be fully dependent. So they should prove that yes, of course, they attain the age of 18, and they are infirm and they are completely depends upon the earning of the employee or deceased. So that's what. So they can claim for a compensation under the Code on Social Security 2020 or Employee Compensation Act 1923. Hope you understood. Hope you can differentiate between a first category and second category. A person, a legitimate son or adopted son who not yet attains the age of whether they are infirm or not or normal, they falls in a first category. But second category people, those people attain the age of 18 because as per the first category, in case if they attain the age of 18, they are not dependent. But in this case, they attain the age of 18, but they are infirm, and now and of course they need to prove that they are wholly depends upon the earning of the deceased. If that is the case, yes, of course, so they can claim for a compensation. More not partly dependent, but wholly dependent. Now we look at the third category. In a third category, what they need to prove? If wholly or in part dependent on the earning of the employee at the time of his death. In category, no dependent, no dependency on earning of the employee. In a second category, wholly they must depends. But in this case, third category, these are all people falls in a third category, or who are all people falls in a third category. They should prove that either wholly or partly they were depending upon the earning of the deceased or earning of the employee at the time of his death. This is what I said. A widower, a widower, who is widower? Who is widower?
So the husband, I mean, the not in the first case you had said it is the wife would not have to prove, but the widower you said is the husband, and they would have to prove that they were married, and that is the widower. Yes.
Widower here, widower, during the time of the death of his wife, can he claim for a compensation? The answer, yes and no, both. When we can say that he is dependent or he can claim for a compensation? When he is depending on earning of the wife. What is the extent of dependency? Either wholly or in part. Even in a part or partly, in case he was depending on income of the wife, yes, of course, like he can claim for a compensation. On the other hand, my answer is no sometime, because suppose if a widower, I mean husband, in case if he fails to explain that, so he was partly or wholly depending on the earning of his wife, so now he cannot claim for a compensation. He cannot claim for a compensation. Because normally what is to happen in a joint family or who does a coolie work or daily labor, usually husband and wife both will work, and there will be like a pooling of fund, and the expenses will be taken from that the pool of fund. This is what usually happens, how they run their family. And when it comes to joint family, we know that how it works. So the especially like a Hindu joint family, uh, in a one house, so there will be like more than 15-20 members, and all family members, they'll collect their fund, and they'll utilize those fund in order to meet the expenditure, family expenditure. If that is the case, so a widower also can claim for a compensation. A husband also, in case if he is able to prove that, so he was dependent on earning of his wife, so now he can claim for a compensation. Question? Any questions? Okay. Now see, who falls here? A parent other than a widowed mother. Why other than a widowed mother? Why other than a widowed mother?
Widowed mother comes in the first category.
Yes, she falls in a first category. Other than a widowed mother. Parent. This is what I said. Parent. Who falls here? Parent. Father and mother. Father and mother. But what they should prove? They should prove that they were depends on earning of their son either partly or wholly. That they need to prove. That they need to prove. See, in one of the case, the main colliery company versus Davis, a minor aged 16 years earning some amount of money per week. He lived with his parents and gave them all his earnings. And what is to he used to earn some amount of money and he used to give it to the parents. And the parents managed for the everything like fooding, lodging, clothing, everything. And even this is the parents who used to like give a little pocket money to him. And even father, he was a coolie. He was a coolie and he was earning like some amount of money. Now, question comes whether father was depends upon the earning of the deceased or earning of the minor. The answer is yes, he was dependent. Why he is dependent? Because by looking at his contribution, we can say that the structure of his family, we can say that yes, a partly even father also depends upon the earning of the son. So that's what sometimes the father or a mother also can claim for a compensation. Compensation. Are you following? Are you following?
Yes, sir.
So what was the case name you just said?
Just now I said the main colliery company versus Davis. Main colliery company. Main colliery company versus Davis. Happened in 1900.
Okay, sir. Thank you.
Okay. Sheetal, have you understood?
The second point I didn't understand.
Then why you didn't ask a question? Ask a question. So dare to ask a question. Have you understood this widower? Who's widower?
In case if we prove that dependent on the like
Mm.
on the earning of his wife.
Mm. So he can claim. So
Yeah.
parents, father and mother, can they claim for a compensation? Can they claim for a compensation, father and mother? Can they claim for a compensation, father and mother? Anybody?
Yes, sir, they can claim.
Sir, they can claim.
Yes,
Yes,
they
sir.
can claim for a compensation.
Yes, sir, they
When
can claim.
Yes. When they can claim? When they were
If they are
depending on earning of the deceased. This is must. They were depending on the earning of the deceased. Okay, we'll discuss next. Now see. Interestingly, legitimate son, illegitimate son. Legitimate son falls in a first category. Illegitimate son falls in a third category. A minor illegitimate son, an unmarried illegitimate daughter, or a daughter legitimate or illegitimate or adopted if married and a minor, or if widowed and a minor. See, a minor illegitimate son falls in a third category. A unmarried illegitimate daughter, because unmarried legitimate daughter falls in a first category. Unmarried illegitimate daughter falls in a third category. Or a daughter legitimate or illegitimate or adopted if married and a minor. See, whatever the case, here a daughter, whether she is a legitimate or illegitimate or adopted if married but she is a minor, or if widowed and a minor, widowed and a minor. So this is what the provisions, updated, and the new provisions was added in a code on social security 2020. So look at here: minor, legitimate son, unmarried legitimate daughter, illegitimate daughter, or a legitimate daughter or illegitimate or adopted if she married and a minor. She is, in case if she married. Unmarried, of course, falls in a first category. In case if she married and a minor, falls in a this category, third category. Or if she widowed and a minor, falls in a this category. Next. Anyone want to read? Yeah, any one at a time.
A minor brother or an unmarried sister or widowed sister if a minor.
See, a minor brother, a unmarried sister, see, or widowed sister if a minor, a unmarried sister, or see here, brother and sister also included here. A minor brother and sister is also included in a third category as a dependent. A brother not attains the age of majority falls in a third category. And what he or she need to prove? They need to prove that they are dependent. Minor brother. Now question comes, brother can be classified into two: the consanguine brother and uterine brother. Have you heard about the consanguine brother and uterine brother? Brother also further classified into consanguine brother and uterine brother. Consanguine brother in the sense father is same. Father is same. Mother is different. Uterine brother in the sense mother is same. Father is different. Now, minor brother, whether we should include even like a consanguine brother and uterine brother, what is to say that half-blood brothers? Can we include both a consanguine brother and uterine brother under this category, minor brother? Can we say that they are the half-blood brother? The half-blood brother also must be included. Even consanguine brother and uterine brother both must be included under the category of minor brother. But what they need to prove? They need to prove that so they were wholly or partly dependent. These two things, in case if they are able to prove, so they can claim for a compensation. So consanguine brother or sister, uterine brother or sister. Clear? So these are all people falls in a category. There are some more people I will explain falls in a third category. A widowed daughter-in-law. See, it is not only a daughter, but also a daughter-in-law. A widowed daughter-in-law also included in the third category, but she need to prove that she was dependent. Widowed daughter. A minor child of predeceased son. See here. A minor child of predeceased son. Who falls here? Who is a child of a predeceased son? During the time of the death of the son, in case son has any minor child, now during the time of the death of, say, the grandparent, of course, the grandfather, so he can claim for a compensation. A minor child of a predeceased son. During the time of the death of the son, I mean, the son is no more. During the time of the death of the grandfather, even minor child also can claim for a compensation, since he falls in a third category. A minor child of a predeceased son. Hope you can understand the word a minor child of a predeceased son. Predeceased son is in son is no more. Grandfather is alive. So during the time, if anything happens to grandfather, so now the minor, the grandson can claim for a compensation. Read this. Read this.
A minor child of a predeceased daughter, where no parent of the child is alive.
See here. A minor child, see, above case, the minor child of a predeceased son. Now, a minor child of a predeceased daughter. A minor child of a predeceased daughter. Now, a father, a daughter, and a child. When child is dependent on the grandfather, when there is no parent of the child is alive, daughter also is not alive, and her husband also not alive. If this is the case, both daughter and her husband is not alive, and child, in fact, so child can claim for a compensation during the time of the death of the grandfather. This is not the case in this case. I mean, the minor child of a predecessor son. Even if the mother of this like a minor child or baby is alive, so still the child can claim for a compensation, but may not be the case of the predecessor son. Both, it happens only when both daughter and her husband is not alive, so child can claim for the compensation from father. Compensation during the time of the death of the grandfather. Is it complicated or understood?
Sir,
Yes.
Sir, could you please repeat the last point again?
Which one? Seventh one?
A minor child. Yeah.
See, have you understood this? The minor child of a predeceased son. A minor child of a predeceased son.
Yeah, sir.
Because the relationship in this case, how it works? I said father, I said son, and I said baby or child. Now, during the, the son is already expired. He already expired. Now, child is a minor, being a minor, if anything happens to grandfather, so grandfather or grandmother, so a baby can claim for a compensation, provided, so the child need to prove that, so wholly or the partly, it was, the dependent on earning of the grandfather. But in this case, so see, in this case, son is already expired, but his wife may be alive. She may be alive. But in this case, minor child of a predeceased daughter, where no parent of the child is alive, this happens in this way: father, daughter, and a child. Now, when child can claim for a compensation from the grandfather, when both child's mother as well as the father is no more, both husband and wife is no more, child can claim for a compensation from grandfather during the time of the death. During the time of the death in sense, so we are discussing about the death during the time of an employment, during the course of an employment. We are talking about the compensation from the employer, that's it. So when they can claim for a compensation, who can claim for a compensation? So that is the question. That's what we are discussing, dependence under this clause. Clause 2, subclause 24. Clear?
Yes, sir.
Yeah.
Thank you.
Any questions? See. Read. A grandparent if no parent of the employee is alive. See, when grandparent can claim for a compensation, grandparent, when they can claim for a compensation, if no parent of the employee is alive. See, we'll discuss here grandparent, and here parents, and here son. Let's take an example of son or daughter. I'll take son. Now, when grandparent can claim for a compensation during the time of the death of their grandson, only when parents are not alive. No parent of the employee is alive. Why this clause? Because it is implied that when parents, the parents in sense, his parents in the sense, a son or daughter of these people. So when parent is not alive, now grandparent, it is the duty of the grandson to maintain the grandparents now. So, but they need to prove that in order to claim for a compensation, their wholly or partly they were dependent on the earning of the grandson. That they need to prove. So grandparent also can claim for a compensation. Yes, last paragraph. Anybody want to read? Anybody want to read?
For the purposes of subclause B and items 6, 7 of subclause C, references to son, daughter, or child include adopted son, daughter, or child, respectively.
Yes, above, whatever we discussed, son, daughter, child includes an adopted son also. That's it. So this is what about the dependence. The dependence. Any questions? So we'll discuss about the disablement in our next class. Disablement, because a claim for compensation can be raised during the time of the permanent partial disablement, or the permanent the total disablement, or the temporary disablement. Under what occasions they can claim for a compensation? So those we'll discuss in a next class. The permanent partial disablement, the permanent total disablement, and the temporary disablement. So that we'll discuss in a next class. So hope you understood the dependence. So these are all people falls in the category of dependence under clause 2 subclause 24 of the Code of Social Security 2020, or under the Employment Compensation Act of 1923. So these are all the dependence list you can found under section 2 subsection 1 clause D of the Employee Compensation Act of 1923. So in case if you look at those sections, you can find. So hope you understood. So during the time of an industrial accident or personal injury caused due to the industrial accident, so how the compensation can be claimed, or who can claim for a compensation. So that we discussed under the clause 2 subclause 24 of the Code of Social Security.